Former President Donald Trump has pleaded not guilty to 34 felony counts related to allegations he falsified business records in connection with hush money payments. Joe Tacopina is one of the attorneys on Trump's legal team, and he joins us now. Mr. Tacopina, I'm just going to jump right in. At its most basic level, it looks like what the district attorney has done here is charge your client with essentially creating a public relations plan that took bad stories and found a way to get rid of them. And instead of paying for that plan with his own money, he falsely claimed it as a business expense. Former President Trump says there was no crime. Is your defense that there was no crime at all, or that he just wasn't involved in this scheme?
There's no crime at all. It's not exactly accurate to say he claimed it as a business expense. He did not. There was no tax deduction taken here. I mean, I'm seeing a lot of stuff out there. You know, this indictment was very vanilla. I mean, it did not list the underlying crimes he's allegedly intended to cover up with those false business records, because
the DA
that's
says
what makes it a felony.
To.
So the DA says it doesn't have to what?
It doesn't have to list the crimes, that's not required by law.
No.
And among those he listed, he said taxes were one of the
crimes, but normally it doesn't have to list the crimes, but normally it does. Okay, you don't have by law to list the crimes in an indictment, but what's to hide? Why wouldn't they bring them forward? What, to get some strategic advantage? I mean, this is not a game. You're charging the President of the United States with crimes that will never be sustained in a court of law because they don't exist. There are no tax deductions taken here. There were no filings with the FEC. FEC has come out and said there's been no violation of FEC laws. So I don't know what crimes we're talking about exactly, John.
But is falsifying business records, just as a matter of course, is not a legal thing to do? And you're saying there was no business records of any kind, whether it's taxes or otherwise? Nothing was falsified ever at all?
Not only was nothing falsified, but nothing was filed. So I could have my own ledger in my checkbook. I could pull out my pocket and write, I'm buying a horse instead of buying a car in my ledger. Whatever. Maybe I don't want my secretary to see that, right? But unless I file that with an authority, like the tax agencies, or I'm taking a tax deduction, or if I'm running for office, I have to file it with the FEC for some reason, there is no crime. I could write whatever I want in my personal ledger. There was no filing obligation. He never filed anything that would invoke a false business record claim, which is a misdemeanor, by the way.
You'll have to work that out with the DA, who says there was a tax violation. Let me ask you about the former Trump Organization CFO, Alan Weisselberg. He is throughout the statement of facts here. He's currently serving because he was convicted on 15 felonies, including falsifying business records. He's obviously somebody who can corroborate the claims of the DA. Will he appear, do you think, as a witness for the prosecution or the defense?
In no scenario will he appear as a witness for the prosecution. I mean, if you listen to his trial testimony, he all but exonerated Donald Trump in any knowledge of anything. He pled guilty to committing his own personal tax crimes. And that's a whole different case with a whole different set of facts and a whole different set of scenarios that happened there that, quite frankly, to me, were unfair, where this guy was pressured, this 70-something-year-old guy was pressured to go forth and take pleas on minuscule things that would never have been prosecuted, except for the fact that he was Donald Trump's CFO.
But so in this case, you have his handwriting on materials that are in furtherance of this deception. You say it has nothing to do with taxes. It may also have to do with campaign finance violations. But I mean, his word doesn't necessarily need to testify, because they've got documents showing him in furtherance of this scheme. So he's not exactly helpful to your client in that regard.
Yeah. No, he's exactly helpful to our client in that regard, because there is no scheme and there is no crime. Let me try and break this down very simply. There's two key elements here. Was campaign money used, or was personal funds used? First of all, it was personal funds. There was no campaign money used because it wasn't a campaign issue. This was done to prevent an unpleasant story.
Well, it would have been a campaign issue if it had come out during the campaign.
John,
of course it was a campaign issue.
Let me finish my answer. It'll get to that. So the second part is simply this. When you have personal funds used during a campaign, the rule of law is for campaign finance was that expenditure made, that payment made solely for the purpose of the campaign? Because if it was made irrespective of the campaign, then it's not a campaign finance violation. Clearly here, even Michael Cohen, when he pled guilty, said this was done in part to prevent embarrassment for the president and his family. That takes it out of the realm of FEC campaign finance law violations. That's why the Justice Department didn't charge him. That's why the FEC didn't charge him. So you have to understand the law here, the campaign finance law. And this is a first. A state prosecutor is bringing a violation of federal election laws. Never happened in this country before.
Final question to you about your client. Former President Trump says, I have a Trump-hating judge with a Trump-hating wife and family. Does that help the case?
It doesn't help the case, it doesn't hurt the case. It's a statement of fact. A statement of fact based on the Daily Mail's reporting and others reporting that the judge's family members work for Kamala Harris.
But you agree
President
that
Harris
it's a Trump-hating judge.
So does it help the case or hurt the case?
It's a fact
What?
that it's a Trump-hating judge?
It's a fact. It's an opinion of someone who's been put through a political persecution, John. It's not a fact. It's an opinion of someone who has the right to feel aggrieved. He was in a, this was the same judge from the last trial, the Trump Organization trial. So there were some issues there. A recusal motion was made there. So it's his opinion. But you act like this is a normal day. He's been put through something that no one else, if he was not Donald Trump, he would not be a defendant. No one else would have been prosecuted in this country for this crime because it's not a crime. It's a campaign. Hillary Clinton, who actually said legal fees for a Steele dossier, which was dirt digging, got a fine from the FEC. He gets indicted for using personal funds.
30 other people have been indicted on this falsifying charge by this DA, but I understand you say that that's not what's happened
not
here.
For campaign, not tied to federal
for
campaign finance law violations, John.
But for the charge on the indictment, which
John,
is,
it has to be
falsifying records.
It has to be tied to a violation of federal election campaign laws. It is not.
My guess is we're unlikely to work this out now, but Joe, I appreciate you going a few rounds with me.